The shoot judgment handed down by the Supreme Court of Appeal was the bone of contention when the state presented its application for leave to appeal in the Free State High Court. In the shoot judgment, the SCA had ordered that only the Minister of Justice has the power to apply for extradition from another country. State Prosecutor Advocate Johan Deneisen told the court that the respondents only raised the issue of the judgment after the state had concluded its case. He argued that the shoot judgment was not part of the case brought by Cholota and her lawyers, and therefore it cannot be the basis of the judgment. He insisted that the NPA was appealing the judgment with the Constitutional Court.
The whole judgment was on the matter of legality, revolving around the decision of Schultz in the Supreme Court of Appeal. Now that clearly, with respect, is a question of law. It's an issue of law, and therefore the state is fully entitled to formulate a question of law in that regard.
Cholota's legal representative, Loubser, however, told the court that the shoot judgment had been legally binding when the NPA applied for Cholota's extradition from the US. Magashule said based on that judgment, the NPA did not have the requisite authority to make that request, also insisting that there was no appeal on the shoot judgment before the Constitutional Court.
And one will note that there is no document or paper or email that the state has placed before this court to say this is from the registrar, the appeal was reinstated, and it is presently before the Constitutional Court for determination. We're all working on the intention of the NPA, and it is an intention that is an afterthought, my lord, not the actual fact of the matter. And while one will note that that is noticeably absent in any of the state's papers.
Judge Loubser maintained that he did not err in his application of the shoot judgment. He said the matter was handed in as an exhibit.
For this reason, the court only informed the accused that she was free to go without acquitting her on the charges. In the premises, the application to reserve questions of law for consideration by the Supreme Court of Appeal is dismissed.
The NPA says it will petition the SCA to appeal this outcome.
We hold the view that the Honorable Judge erred, and therefore there are prospects of success on appeal, and that there are compelling reasons for the appeal to be heard by the Supreme Court of Appeal. It should be noted that the merits or strength of the state's case was never ventilated nor adjudicated, nor was it pronounced by the Honorable Judge during and after the trial within a trial.
Mhaga says the state has 21 days within which to file the said petition. SABC News, Bloemfontein.